Good afternoon from Chisholm, and Kilpatrick. This is Zach Stoltz with my colleague Brad Hennings. We are going to do a quick take on a major decision in veterans law and in administrative law generally that was handed down from the United States Supreme Court today. It's a case called Kisor, K-I-S-O-R v. Wilkie. You'll find a link to the decision and some commentary on it in the coming days and weeks on cck-law.com. It is a major decision. There are 80 pages of legal writing involved in the decision, so we've been digesting it for a large part of our day today, and I'm going to just go ahead and give a disclaimer that we still don't know everything about it. We won't know everything about it for a long time, how it's going to play out practically. We're going to get into some reasons for that. But first, just to give a little overall view of what happened in Mr. Kisor's case, and then I'll read to you what the Supreme Court said. This case originated at the Department of Veterans Affairs. It worked its way up to the Board of Veterans Appeals, then to the CAVC, the Court of Appeals for Veterans Claims, and then to the Court of Appeals for the Federal Circuit, and ultimately to the United States Supreme Court. So it has been going on for a very, very long time. Mr. Kisor is a Vietnam War veteran, and I'm going to do what makes for some relatively bad TV, but I promise it'll only take about a minute. I'm just going to read to you from the decision just a little bit of what happened in the case, starting at the Board of Veterans Appeals. The board acknowledged that Mr. Kisor had come up with 2 new service records, both confirming his operation in Operation Harvest Moon, but according to the board, those records were not, quote, relevant because they did not go to the reason for the denial that Kisor did not have PTSD. So Mr. Kisor is, to give a little background, he's claiming service connection for post-traumatic stress disorder. VA denied that. One reason they denied that is because they did not put him in the place that he says he was for the stressful event that triggered his post-traumatic stress. So getting back to the decision, the board said the documents were not relevant to the decision in May 1983, so that's how long this has been going on, because the basis of the denial was that a diagnosis of PTSD was not warranted, not a dispute as to whether or not the veteran engaged in combat. The Court of Appeals for Veterans Claims, an independent Article I court that initially reviews the board's decisions, affirmed for the same reason. The Court of Appeals for the Federal Circuit also affirmed, which means they continued to deny Mr. Kisor's claim, but it did so based on deference to the board's interpretation of a VA rule. And the VA rule at issue in this case is 38 CFR section 3.156C, and the gist of that, and I know this gets lawyery, but the gist of that is that if service records, if relevant, and that's the key here, if relevant service records come into a file, even if the claim has been previously denied, if relevant service records come in that should have been associated with a veteran's file at the time of the denial, then the board or VA is supposed to look back and perhaps award major retroactive benefits because it was their mistake that service records were not associated with the file. So that's what the fight is over. And the fight is over whether or not what Mr. Kisor and his attorney submitted qualify as relevant service records. And so there's a whole fight for years and years and years between the Department of Veterans Affairs and Mr. Kisor over what the word relevant means, and another layer on top of this, who gets to decide what relevant means. And so the Supreme Court, in basically a 9-0 decision, said what, Bradley?
Well, what they said was that the Federal Circuit made a mistake. Basically, everybody made a mistake up until they got to the Supreme Court, and that what they called our deference, or deference to agencies' interpretations of their own regulations, should only be afforded in very narrow, limited circumstances. And so that the courts before the Supreme Court made a mistake when they went ahead and allowed this agency deference. Basically what that means from the VA's perspective is if something seems ambiguous in a regulation, unclear, let's say, VA says, well, we're entitled to deference, meaning you should listen to our interpretation, you should listen to what we think, and you have to defer to it.
Right. So for years, since 1945, since World War II, there has been a long-standing mechanism by which courts are supposed to defer to an executive agency's interpretation of a regulation, which is to say that if one of the many departments of our federal government, the Department of Defense, the EPA, the Department of Labor, or in this case, the VA, writes a regulation, they should be able to tell a court what it means, as long as what they're saying is determined to be, quote, reasonable. And that's been going on for, like I say, over half a century now. And there has been a movement afoot to overturn that long-standing precedent because the argument goes that it has given these agencies, all of these agencies, and the federal government in general, way too much power. Because not only do they get to write what the rules are, they also then get to say what the rules mean, cutting out what courts are supposed to do, which is to interpret the law. And so there's been a major fight over that, and Mr. Kisor got caught up in the middle of that fight. And the takeaway from today's decision is, while the court is not going to overrule that, they will still allow for there to be deference to the agency's interpretation of their own rules. Justice Kagan, who wrote the decision, really wrote a lot of pages about how the Auer standard, which is the case, AUER, and this deference is supposed to be really kind of curtailed and really only done in special circumstances. And so one could read the decision. Certainly Chief Justice Roberts, who concurred in the decision, would say this severely weakens that deference to the agency, although it does not overturn the president, and Justices Gorsuch, Thomas, and Kavanaugh, and Alito would all say that it probably didn't go far enough. Nevertheless, Mr. Kisor technically won with all the justices. All 9 of them said Mr. Kisor deserved to win. And what does the win look like here?
Well, so what the win looks like is that this deference will not be provided. This Auer deference that we're talking about is not going to be provided to the VA for Mr. Kisor's case. And so it makes it that much more likely that he could ultimately prevail on his claim for benefits. In a bigger picture for VA, it means that when the VA says you should defer to our interpretation of the regulations, the courts will not immediately go to that deference. They will go through what they call different canons of construction, different tools to analyze regulations before they ever get to the question of whether deference should be provided. So ultimately, it means that VA will not be deferred to in the way it has been for many years.
For Mr. Kisor, he's not done yet. All the court decided today was that Mr. Kisor's case, aside from all of this, which has a lot of interest to a lot of different lawyers, not just VA lawyers, although very important to us, but for anybody who deals with a federal government agency in any way, this decision is going to touch them in some respect. Maybe not drastically, honestly, but in some respect it will. But for Mr. Kisor, his battle is far from done with the Department of Veterans Affairs. This is going to have to go now back to the Federal Circuit. I don't know for sure what will happen, but I imagine there will probably be more argument. And Mr. Kisor is going to come in and say, that the regulation says what I say it says, and the VA is still going to probably come in and say, it means what we say it says, and they'll fight over that. And then it'll probably continue on back to the Veterans Court with some more instructions and ultimately back to the Board of Veterans Appeals. Poor Mr. Kisor is probably not out of the woods. But major decision for his fellow veterans. It's a very interesting case, a very, very interesting outcome. We think probably a good outcome for veterans. Time will tell. But the initial read of it is that this is very good for veterans because it does curtail some of the power that VA has enjoyed for these past 50 to 60 years. So even if it's not an earth-shaking development, it certainly should be able to help some veterans out.
And as you alluded to earlier, one of the big criticisms of this Auer deference, this deference to the federal bureaucratic agencies, is that it's fundamentally undemocratic because they don't have the same level of responsiveness as, let's say, the elected branches of government. So I think this really is a great opportunity for veterans to no longer have to worry that the VA is always going to be deferred to when they try to interpret their own ambiguous regulations, which frankly, as anyone who's worked in veterans benefits knows, these are complicated and confusing. So
that is CCK's quick hot take on the Kisor case. There will be much more information to come. It will be on our website, cck-law.com. We certainly, our advocates here, will certainly be using Kisor to the best of our abilities to help our clients out. And I'm sure that veterans advocates across the country will be doing so as well, but certainly we here at CCK will be doing so. And we thank you very much for listening in and watching today.